Ladies and gentlemen, good day and welcome to the webinar on Cross-Border M&As in the Indian Sector Technology. This event is being organized by Nishith Desai Associates. The speakers are Webunar+, Partner, Private Equity and M&A, Nishith Desai Associates; Rajesh Simon, Head, International Tax Practice, Nishith Desai Associates; Huzaifa Tawawala, Practice Co-Head, Nishith Desai Associates; and Karan Kalra, Practice Co-Head, Nishith Desai Associates. As a reminder, all participant lines will be in the listen-only mode, and there will be an opportunity for you to ask questions at the end of today's discussion. Should you need assistance during the conference call, please signal an operator by pressing star then 0 on your touch-tone phone. Also, you can download our mobile applet, Nishith Mobile, which is available on the App Store for iOS device, Play Store for Androids, and BlackBerry World to access the current updates and videos. Please note that this conference is being recorded. I would now like to hand the over session to Mr. Webunar+. Thank you, and over to you, Mr. Parikh.
Thank you. Thank you for being here. We are keeping this. So, people, friends from India, thank you for being early. People from California, thank you for being late. The timing has been chosen specifically keeping in mind the audience all around the world. Today we are talking about M&A in technology sector, and I just thought let me introduce the subjects and see where we are looking at M&A in technology sector, and then go through some of the issues which we have come across and give our experience on what to expect issues and how do we address those issues. Generally, M&A has been on increase. Our last 2-year experience says that we are seeing steady increase in M&As in technology space, and the way the technology sector is booming, we do expect that in next 3 to 5 years you will have even more or increased number of M&As going forward. When I look at technology sector for M&A, I will broadly divide it into 2 spaces. First space where we are seeing activity is in traditional software services / BPO space, where most of the companies are mature. When we are looking at M&A, they are of mature company. They are relatively larger companies. The transactions are larger. The reason why we see acquisitions happen are primarily because these companies are generally cash rich, or they have a good client customer base, they have a good set of people, a large number of peoples, and when the investor and the promoter has done enough and they feel that getting an exit at this point of time would give them good returns. The reason why this company are acquired, from acquirer perspective, they see that look, this company has done well, or they have a good fit with their set of clients or their set of technology. Sometimes they have a complementary verticals, which is the other reason why they get acquired. So that's a typical profile of what kind of acquisitions we have seen in software services business or BPO business. There have been a steady number of such acquisition, and we expect this steady number to continue in next couple of years. We don't see this to dramatically accelerate number of acquisitions, but it would remain the way it has been happening. The other sector which I would divide the M&A in technology space would be the newer sectors, like for example the internet companies, the app companies, the mobile companies, etc. where we have started seeing acquisitions happening in last couple of years. Generally, the acquisition happened because of consolidation, because of, we'll see distress acquisition too in this space. We see that next 2 to 3 years, this space will be much more active than what it is now. Specifically in area of mobile, in area of edtech, education technology, area of health tech or medtech as it is called, area of fintech. This is where we feel that there will be a lot of acquisition. Here, unlike the software and BPO space where generally the companies acquired are mature companies, here they are going to be much more at the initial stage. As I said, some companies, it may be even a distress sell, which means company has done reasonably well but not good enough and really has no future. And as a result, the investors say, let's exit. There we are going to see generally a low value deal, unlike on software services where generally our experience is that the acquisition price is high. Here we are also likely to see more of a stock kind of a stock swap kind of a scenario, or even sometimes low cash or no cash, and generally stock given to founder as an ESOP, which will vest over a period of 4 years. So this kind of trend is what we are seeing currently, and we expect to continue. There also will be acquisition because investors have actually the company has done well. The investor says it's time to make profit and let's consolidate and sell it off. So you will see companies which have been successful or reasonably successful or leader in their space getting acquired by either an existing company or another internet company for consolidation purposes, but that would be generally a higher value deal. So this is where we are looking at acquisitions happening. The issues which we see in both sectors, which is the software services BPO sector, where acquisitions happen mainly for people and customers, and the product vertical, there the main issues we look at or we come to is people issues, which is labor law or employee related issues. We come across tax issues, with a lot of transactions are structured as earn-out, and so on and so forth. On the other hand, when you look at the tech space, generally the acquisition happens because of either founders or because of the intellectual property, whether it is in terms of the position which that company has, or whether in terms of the app which they have built, or whether it is in terms of the back-end technology what they have built, or it may be because of certain domain expertise or certain knowledge which their employees or their founders have, right? So IP is a lot more important in this sector than some of the other ones, mature ones. Again, when you look at acquisition, structuring issues always become very, very relevant. Primarily because there are a lot of foreign investors. The company may be either headquartered in India, or it may be sometimes headquartered outside India. Even when you look at companies acquired, companies which are targets, even they will be headquartered outside India, or they may be headquartered in India and have shareholders both in India and outside India, and that ends up complicating or creating a lot of structuring issues. So what we have seen is one of the key issues in this whole situation is on the structuring side. We will address structuring as a part of our session, as that is where we feel a lot of issues come up. Also, in software services side, the other sector, what we have seen is there are a lot of Indian companies which have done well, and they do an outbound acquisition. And that are the another set of transactions we have come across, and it brings its own challenges and own issues. So we'll address even that too. With this introduction, I think we should straight away get into, I will ask questions from the panel. All three panel members are extremely experienced and knowledgeable in their area. First, I will pick up, let's say, on the structuring on the tax side. As I said, that's one of the more critical aspects. First question to Karan. Karan, I just touched upon outbound investment. What are the key structuring elements in the outbound investment that an acquirer needs to consider? And can you share your experience on financing options that are now available?
Sure. Thanks, Weber, and thanks for that introduction. As Weber mentioned, outbound investments out of India is actually a growing number. If you look at some of the statistics available over the last 3, 4, 5 years, you actually see this M&A number to be either equal to or even greater than the inbound M&A number. Now, why is that? The first thing to think about is, and why is that in our particular sector? First thing that comes to mind here is, Indian companies typically, and if they're subsidiaries of foreign companies, kind of work on a cost plus basis. So they're cash rich entities. As we all know, taking out cash from Indian companies has always been a challenge. It's not very efficient. There are other restrictions that are also involved. And therefore, if you're a global conglomerate with presence in India and you're cash rich in India, you might want to use this cash to think of an acquisition outside. In fact, we've seen that happen in a number of cases, and certain acquisitions that we've seen even in the recent past. Another reason is the growth of Indian companies overall. If you look at it over the years, the size of Indian companies and the size of companies in the tech sector has really matured. This also gives them the ability to now have the cash and resources to go out and acquire, make acquisitions, and really grow in this space. From a structuring element, and I'll of course leave the tax aspects to my colleague Rajesh, who understands this a lot better. But really, it's what do we have to critically look at? The Companies Act will be a challenge, and it always is, to be able to structure what you can do. But the one that becomes key here are our exchange control regulations. Now, unlike inbound investments, where there are no real limits as to how much you can invest in, like the inflow of FDI and FII money into India, outbound investments is somewhere where India has always been conservative. We actually cap the amount of investment that an Indian company can make towards a foreign acquisition or towards a foreign setup, etc. With the reason to do this is, of course, our limited capital account convertibility. Now, this cap is presently today at 400% of the net worth of an Indian company. The net worth is calculated as your paid up share capital and free reserves. And what it really says is that the financial commitment of an Indian company towards its foreign liabilities is capped at 400%. Now, what is this financial commitment? It's really cumulative of the actual amounts you've invested towards acquisition of shares, any amounts that you've advanced towards a loan to one of your entities offshore, which is either a joint venture entity of yours or a wholly owned subsidiary, or it also the amounts contributed or agreed to be contributed towards guarantees that are given for the purposes of borrowings or other other commercial businesses that your offshore entities operate. On guarantees, again, the 100% of the amount is calculated so long as it's a financial guarantee. But for performance guarantees, it's 50% of that amount that gets calculated. Now, what this does is it's giving you a good structuring flexibility. You can either just go out outright and acquire the equity using the Indian company, or of course, you can use that money, lend it to a foreign company, say an intermediary company or a step-down subsidiary, that then can use these monies for the acquisition. You can give the guarantee as well, which is also very helpful because the source of funds in a lot of foreign jurisdictions is a lot lower, and you can actually borrow offshore and use these and use the guarantee as the collateral for that, amongst other collateral that you'll be giving. One place where you're restricted, and this is common for all acquisitions, whether inbound or outbound, is financing within India. Indian banks are largely restricted to lend for acquisition financing. and therefore you tend to go to higher sources of financing such as NBFCs, etc. But another route that's kind of been helpful here is the non-convertible debenture route, where you can actually raise monies from offshore or even domestically by issuing debentures and use the proceeds of those towards your acquisition that you're going to do offshore. We spoke about companies doing this. The same leverage is also and the same regime is applicable to registered partnerships, and they too can make such acquisitions. The target that you're acquiring, if it's an unlisted or an unlisted company or an unlisted target, it's fairly simplistic and these limits apply. If it's a listed target and you're going to acquire listed securities, other than following the requirements for an open offer or other listed acquisition that will be there in place, your limit is also actually reduced to 50% of your own net worth. The reason for that is not really focused towards doing an offshore acquisition, but the regime applies to offshore investments as a whole. And since listed acquisitions could be volatile to some extent, this cap has been kept lower than the cap that's there for unlisted acquisitions. Another common feature that you should think of while thinking of how you're going to finance these is that this 400% limit actually does not apply to foreign source funds of that Indian company that exists. So if you have an accounts payable, you can use those. You can in fact capitalize that as well and do it. Or if your balances in an EFC account, that's also something that you can utilize without the limit on these caps. Coming to M&A, when you're acquiring or you're more when you're merging, you're also thinking of doing an equity swap, which is often more efficient because you don't go cash out. While that's permitted, that's under the approval route. So you will need an RBI and an FIPB approval to do that. But it has been done, and as long as you are doing it for a genuine business purpose, there shouldn't be a concern. There are certain restricted sectors, and I won't get into them and how you work around them since it's not the topic for today, but real estate business as such is a restricted sector. Investing in banks is also a restricted sector, largely on account of the systemic risk. And also we heavily regulate if you're doing an acquisition in a financial sector outside. Again, not the topic for today, so we'll avoid that. But when I say financial sector, what's good to know is that you're allowed one level of holding company or a step-down subsidiary when you're doing an acquisition. So say when you're acquiring a target which is in country X, you may want to set up an SPV in country Y for various reasons, maybe your fundraising there, your tax efficiencies, etc. And that's permitted, and that's not going to be a financial sector acquisition, even though that intermediary company is merely a holding company. Other than that, I think a couple of important things to look at is valuation concerns. It's stipulated how you must always submit your valuation certificates when you're doing such acquisitions. While the principles are similar for valuation as they are for an inbound acquisition, you're not limited as really that whether you can go above or below the valuation, so long as your valuation is justifiable. Also, the test here is a delegated power that has been given to authorized dealers from the Reserve Bank of India. Therefore, if your authorized dealer is comfortable with the submissions you're making, even though the onus of doing everything kosher is on you, to some extent you get the comfort that they understand what you're doing and they're okay with what you're doing. Their experience also lends in comfort so that you're not really going outside the line to get these done. There are regulatory filings that need to be done when you make such acquisitions. There's a yearly filing and at the time of the filing itself. But really once it's done, there's no more approval mechanism that's really in place. So really, I think the short point being from the structuring element, while there are some boundaries and there's a limit on the cash that you can do, there's a lot more flexibility that's available even against inbound acquisitions to a great extent. I hope that it is.
Thank you, Karan. One reason why all what Karan said is very important is a lot of acquisitions on outbound happen because you have software services company which has done well in India, and secondly because also there are a lot of foreign software services company which has cost plus base set up in India. And when you have a cost plus base setup in India, you are always going to have cash sitting in that particular company. And using this cash for purpose of acquisition is a very good way of making good utilization of this cash and extracting the cash out for the purpose of foreign company. So that's why we see this more in use. Thank you, Karan. Let me ask my next question to Rajesh. Rajesh, what are your thoughts on key tax issues that are relevant for outbound acquisitions, particularly in relating to technology sector? And please share your thoughts on jurisdictions which such companies should consider, keeping in mind the sensitivities around technology, taxation, and IT.
Thanks, Vaibhav. I think the first thing is that whenever you're looking at an outbound acquisition, there is always a choice that's available. The choice being that should I actually acquire the target company directly, or should I set up an intermediate holding company to actually facilitate the acquisition? And the choice is really driven by a couple of commercial considerations. The idea being that if you're going to be looking at multiple acquisitions, where there may be a need for you to actually have movement of proceeds from one jurisdiction to another, you would actually consider having an intermediate holding company, because in a circumstance where you're directly holding the company, any distribution which is made by the target company in future is actually subject to tax in India. So which is why for you to achieve tax deferral, a lot of times companies do consider having a holding company. The second key reason is also whether you get a tax arbitrage in situations where you actually invest through a holding company as opposed to investing directly from India. And that tends to happen in a number of situations where, for example, if there is a potential tax consequence either on dividend payout or on capital gains in case of subsequent disposal, where you may at times get arbitrage in terms of actually using a holding company. The third key aspect that also sometimes necessitates the use of a holding company is in terms of financing. A number of times where you're actually considering having to actually leverage through a financing option for any acquisition, there are two possibilities that always arise. One is that you actually undertake a financing based on the target company's balance sheet, in which case you actually take a financing directly at the target company level. Or the second possibility is that you want to take a financing at possibly the holding company level. There may be different commercial considerations which actually drive as to which level you would actually want to leverage at. There is obviously one downside that's always going to be there if you take a financing at the holding company level as opposed to a target company level. That being that when you take a financing at the target company's level directly, any interest payout which is usually paid out is available as a deduction from the operational income of the target, whereas in a holding company that may be an incremental cost, because the holding company may not necessarily have significant cash flow, at least in the initial years, when in the absence of any disposal or dividends coming through. But from a broader perspective, what we have generally found is that even, especially in the tech sector, that it's never a one-off acquisition. It's always a string of acquisitions that you would want to consider doing over a period of time. And that sometimes sort of pushes people towards saying that let's actually consider having a holding company, which can then actually undertake the group acquisitions as a whole. In terms of choices of holding company jurisdictions, we have seen a number of different options which have been used by people. There are a bunch of European countries which actually have a good holding company regime. This can be countries such as Netherlands, UK, Ireland, or Switzerland. And a lot of the reason as to why companies actually use some of these European countries as a holding company is because some of the key benefits that they get, because most of these countries have a regime, what is known as a participation exemption. which essentially provides that there is an exemption as far as any capital gains or dividends which are received from the target company or from the disposal of the target company in the country of the holding company. The second aspect is that in some countries, for example, Switzerland is a good example. If there is any IP which is actually vested in the holding company, and let's say it's earning royalties from the US, that is actually not taxable. That's considered to be business income and not really taxable. So there is always going to be people actively consider most of these European countries as a holding company option. The second set of option is something closer to India, which is people also consider Mauritius or Singapore a lot of times as far as acquisitions are concerned. One big downside that's always going to be there with Singapore and Mauritius, especially when you're looking at US acquisitions, is the fact that neither Singapore nor Mauritius actually have a tax treaty with the US. So there can be some downside in terms of using Singapore or Mauritius as a holding company, especially for US acquisitions. The other aspect which is also important whenever you're considering a holding company is the fact that a lot of countries, and especially if you're targeting acquisitions, for example, in the US, the US treaty with most of the countries have what is known as a limitation of benefit provision, which essentially limits the circumstances when treaty benefits can be availed. And that's something that becomes critical, especially when you're considering using these holding companies for acquisitions in the US. The second question which usually arises is that even if you're looking at doing an acquisition, do you really do a stock acquisition or do you do an asset acquisition? And again, the simple issue that arises is that usually if you're doing a asset acquisition, you get a step up in basis which can then potentially be available for depreciation purposes, which is not really the case as far as stock acquisition is concerned. But having said that, in case of an asset acquisition, there is usually a two-layered tax, one in the hands of the seller and the other in the hands of the shareholder if there's going to be upstreaming of dividends. Asset acquisition probably works best in situations where you're looking at, let's say, a partial hive-off of a business, but not necessarily in case of a sale of business in entirety. There is a variation in concept which you can actually find in some countries, especially for US, for example, where you have the ability to do a stock acquisition, but for the purposes of tax purposes, it can be treated as an asset acquisition if both the buyer and seller decide to make an election, which is really what's known as a 338H election. The third issue that is also sort of critical, and it becomes critical from an Indian perspective, is some of the recent changes which have really happened in the Income Tax Act. Because what the Indian Income Tax Act had actually introduced is this concept of place of effective management. And this becomes important whether you're having a holding company or whether you're holding the target. Because the question is that are there potential circumstances where these entities can be treated as residents of India? Until the last year, the test that was really prescribed was that a foreign company would be deemed to be a resident of India if the complete control and management of the company actually was in India, and control and management essentially meant the board of directors. We've decided to move into a place of effective management test now, which essentially says that a foreign company can be looked at as a resident of India if the place of effective management or the place where the key decision making powers happen is in India. The question that always arises is that if I have a number of people in India who are actually taking or steering some of the key decisions of the target company or the foreign company, there are circumstances where that may potentially trigger the foreign company to be treated as a resident of India. This is an issue that we are actually seeing quite a bit as far as Indian MNCs are concerned, where the worry is that's always there is that can the foreign company be treated as a resident of India? The next issue that also arises is the concept of controlled foreign corporations. India doesn't today have the concept of controlled foreign corporation, which essentially means that if you're holding shares of a foreign company, which essentially earns only passive income, that income will essentially be taxed in India in the hands of the parent. There have been talks of introduction of the CFC regime. That was one of the proposals that was there in the direct taxes code, but eventually that fell through. Having said that, today with the OECD actually looking at this actively, and the OECD actually pushing people or countries to adopt the CFC regime. So this is one of the aspects that will always be looked at, even from a future structuring perspective, as to whether a potential CFC regime can have an impact as far as structuring is concerned. Again, that's just a flavor of some of the various issues. So over to you, Webunar.
Thank you, Rajesh. Huzefa, let us come to inbound transaction. We see that a lot of foreign companies acquire Indian companies. And would you like to provide insight on broad legal and regulatory considerations which they need to consider, and give us a little bit of your experience and what you've seen?
Sure. Thanks, Ram. Actually, I'll split this response into a couple of points. One is when we are looking at stock acquisitions, that's a direct stock acquisition or it's also an indirect stock acquisition. There are other variants as to how you can acquire Indian companies, because under the technology space, the core is the IP, which is the technology, and the employees. So we've also seen, other than stock acquisitions, business transfer, sales, you got asset purchase sales. So those are other variants which are pretty popular. But coming back to a direct stock acquisition, whereby an overseas company is actually buying stock of the Indian company, that's a pretty cookie cutter model. But I think apart from the usual issues which come up, the tax issues are relevant. Which is that how much money is actually attributable on that front, and are there any withholding taxes when there is a transfer between a non-resident and another non-resident in relation to an Indian company. The indirect transfer is actually more popular in the tech space. Looking at the entire piece, you'll have an overseas company which would be doing the operating business, which at times is supported by the Indian affiliates or the Indian subsidiaries. And when there is an exit or when there is a sale, the sale is of the entire cake, which means the entire operations are sold. In those situations, though technically there is no direct stock transfer of the India piece, there is a stock transfer at an offshore level, whereby indirectly the India piece gets transferred. In those situations, couple of key points which need to be always factored is that the consideration which is attributable at an overseas level, how much of that consideration is actually attributable to the India leg of the transaction. Depending on that, there could be tax ramifications, which my colleague Rajesh would delve into further detail. Another important point at this, in such transactions which we need to be mindful of, is when the Indian operations or when the Indian companies were set up, say by the foreign company, did they factor in the exchange control compliances? If there were further infusions of funds to operate the business, were pricing mechanisms met? So all of these things also need to be factored, though it looks as if the transaction is happening at an overseas level, but eventually there is an India piece which cannot be forgotten. We just need to ensure that all loose ends are tied up at an India level. Karan actually broadly touched based on the ODI front, whereby the Indian companies are making investments outbound. We've also seen a lot of hybrid models in these situations when we're looking at inbound, which means that the Indian company or the Indian investor has actually set up a structure which is an overseas structure and he's exiting out. So though he's exiting out at a US level, but the US company was actually set up, or any other foreign jurisdiction was actually set up by the Indian company or the Indian individuals. At that point in time, we again need to circle back to ensure that the ODI requirements were met, and relevant exchange control filings and compliances were made. So this is just a flavor on variants of direct and indirect stock acquisitions. The other pretty common ones are technology transfers, which is synonymous and linked to asset purchase agreements, where the acquisition is mainly done for the IP, and in those cases, the assets are cherry picked, or the assets or the IP is cherry picked, or it's taken away as a whole. From an Indian perspective, whenever there is an asset purchase deal done, one needs to be mindful of 2-3 key issues. That of course there would be a stamp duty impact at an India level, there would be a VAT value added tax impact on the India level, and in the same spirit there are certain employee issues. How does the employees get transferred? Because I mentioned that in the tech space, IP and employees are critical. So I will touch base upon employees a little later, but this is broadly on the asset purchase front. We also have another variant which is called a business transfer, which is also a popular mode of acquiring businesses, where the entire business is hived off as a going concern to the buyer. Advantage of that is that the VAT levy which is there in an asset purchase does not get levied under a business transfer. But under a business transfer, another important issue which always needs to be factored is the issue on successor liabilities which tend to come in, which of course my colleague Rajesh may give further insights on. So these are a few ways of which an acquisition can happen in the tech space when you're particularly looking at inbound. And over to you, Rajesh and Weber, to take this forward.
Thank you, Zephyr. I think Uza mentioned about all the issues which you encounter if you're doing inbound transaction, and if you notice, tax has been the key issue. So obviously the next question would be to Rajesh to understand on the tax side. Rajesh, can you talk about the tax consideration which you look at it, you come across in an inbound transaction?
So when you're looking at an inbound transaction, there are 2 or 3 key issues that always tend to crop up. The first one is the fact that does the seller have a tax liability or not if you're doing the stock acquisition, in which case questions also arise as far as if potentially the seller is availing of treaty benefits, should there be an indemnity or not. Tends to happen quite a bit whenever we are seeing that the seller is located out of Mauritius or Singapore, which has certain capital gains tax exemption under the tax treaty with India. So that's always a key sort of negotiation point, which always tends to come up. And in the past, we've also seen situations where a number of times the tax indemnity insurance has been taken. Today, the market for providing insurance is slightly tepid, so to that extent, sometimes it's tough to get it. The second key issue that tends to arise is that why do a stock acquisition? Can we do an asset acquisition? And in the Indian context, asset acquisition can be structured in multiple different ways. You can do what you call as a piecemeal acquisition, where you sort of cherry pick on the assets or the liabilities that you really want to pick up. So if there is a foreign acquirer sets up an Indian company, or if they have an existing Indian company, that just does a cherry picking of the assets and liabilities of the target. The second possibility is a transfer of the business as a going concern, which is also known as a slump sale, where effectively the complete business is actually hived off along with assets and liabilities to the acquirer. The key difference in the tax treatment between a stock sale and asset purchase and a slump sale or a sale of going concern is really this. Stock sale, there is going to be an incidence of capital gains tax in the hands of the shareholders. The rates of tax can vary depending on the location and the nature of the seller. In an asset acquisition where there's a cherry picking of assets, there is going to be a tax that's going to be there, but the method of computation of capital gains tax liability potentially is going to be different, where you're effectively going to be seeing whether the assets are depreciable or not to see what the actual gains are going to be there in the hands of the seller. The third one is slump sale, where you effectively look at the net worth of the undertaking and see what is the consideration you have received over and above that, and that's actually subject to tax. Obviously, in both asset acquisition as well as in the case of slump sale, the actual consideration amount flows into the seller and not to the seller shareholders, which is going to be the case in case of a stock acquisition. Josefa mentioned the point of successor liability. Both in the case of a slump sale or in the case of a stock sale, there is a potential issue as far as successor liabilities are concerned. As far as stock sale is concerned, in any way you are going to be taking over the target, so you're always going to be liable as far as any past liabilities are concerned. As far as slump sale is concerned, you are potentially liable for the year in which the transfer took place and the year preceding that in certain situations. In an asset sale, the risk of a successor liability sort of reduces to a certain extent. The second issue which I did want to touch upon was the question of earnouts, and that becomes sort of critical, especially in the tech sector. Where in a lot of situations the management, the promoter also sort of doubles up as a management, and any acquirer really wants them to continue, and there is an additional incremental incentive provided through the earnout compensation. A key issue that always arises in the Indian context is whether the earnout should be treated as compensation or consideration, which essentially means that should it be treated as potentially salary income, or would it partake the nature of capital gains? And there have been multiple conflicting judgments on this point. So this is always a risk issue that tends to come up. The third issue, which I also wanted to sort of touch on, was the issue of swap of shares, which sometimes tends to be pretty common in the tech sector when you're looking at a lot of consolidation that's happening. You effectively have a situation where the sellers want to actually get, when they are selling their stake in the target, want to in turn get a stake in the acquirer company. Unfortunately, in India, that tends to trigger a tax consequence, even though there is actually no realization event, because we don't sort of have the concept of carryover in basis in such situations to the acquirer company, where the seller essentially swaps his shares in the target into shares of the acquirer company. So that sometimes ends up being complicated in terms of everyone trying to structure it in a manner which at least optimizes or reduces the tax liability. The last point which I'll touch on is really on indirect transfer. Again, these are situations which, as Josefa mentioned, very common in the Indian context, where the acquisition is actually going to be of a foreign company having a substantial Indian subsidiary or operations in India. In these situations, probably everyone thought that post Vodafone the issue was sorted out, where the Supreme Court had said that, well, if there's a transfer of shares of a foreign company by another foreign seller, that cannot have an Indian tax consequence. The government had amended the Income Tax Act to say that, well, even in those situations, there can be an Indian tax consequence if a substantial portion of the consideration or actually arose from the Indian business. And to that extent, they had put in a 50% sort of threshold, which is a pretty low threshold. So that sometimes becomes a key consideration, especially when we are looking at indirect acquisitions. And the last issue is really where sometimes there's a piecemeal acquisition where you sort of have a situation where the stock of the foreign company is purchased, and along with that you have asset acquisition which happens at the India level, where you just pick up the Indian assets, possibly sometimes at book value, questions always get raised on these kind of transactions as to whether transfer pricing applies and whether there needs to be a different notional fair value that should be attributed to the assets. So I think those are some of the broader set of issues which are, I think, more specific to tech industry than a lot of other industries when it comes to some of the tax issues.
So on this last point, just a very quick comment. When Rajesh mentioned that a common thing is at a US level there is a stock purchase, and at an India level there is an asset purchase. What we've commonly seen is, what clients do at times is they make a lot of references of the India leg, the India piece in the US documentation, which actually justifies in some way that a lot of value is being derived in the offshore transaction from the India piece, and that may have adverse tax consequences at an India leg. So just, even when you're structuring it, it is better from a hygiene perspective to ensure that the India leg is treated as an independent leg and not too much of value is attributed in the documentation which is overseas. I just thought I'll make a quick comment on that.
Thank you, Zefa, and thank you, Rajesh. Just one comment before I move on what we have generally seen in tech sector. And what I alluded in introduction also is that there are a lot of companies, both acquire and acquiree, are foreign owned and controlled. And because when you have a foreign owned and controlled, let's say Indian company acquiring another company which has shareholders both in India and outside India, there is a very interesting situation which comes up. As you know that exchange control is something which governs any transaction between a foreign company and an Indian company. And if your foreign entity which is acquiring Indian company shares of Indian company from Indian shareholders, then you have minimum pricing applicable, which means that the minimum price, which is fair market value, which a foreign company has to pay to purchase shares from a shareholder. Similarly, there is a reverse situation where when an Indian company is acquiring shares of another Indian company from a foreign shareholder, then there is a ceiling which is applicable, which is the maximum price which Indian company can pay to the foreign shareholder is the fair market value. And this pricing guideline is also applicable to foreign owned and controlled company as if it was a foreign company. So really question comes in when a foreign owned and controlled company acquires shares of an Indian company both from Indian shareholder as well as foreign shareholder, then in that situation will minimum price be applicable or will the ceiling be applicable? And how will pricing regulations be applicable in this particular situation? And what we have seen is that when a foreign owned and controlled Indian company buys shares from an Indian shareholder, then they have to pay minimum fair market value to the Indian shareholder because of the pricing guideline applicable to them. But when the same Indian company buys shares from foreign shareholders, then they will be treated as an Indian company and a ceiling will be applicable. And now both the pricing, the minimum price and the ceiling are at fair market value. Realistically speaking, you can only do transaction at a fair market value in such situation. And in that case, how will you do indemnity escrow, or if you do let's say earn-out, it would always become a challenge and a very important aspect to consider from structuring perspective. With that, let me move on. I'll go back to Huzefa. Huzefa, what are the issues that are unique to technology companies in relation to intellectual property ownership, employee transfer, and integration? And what do you suggest on addressing the issue?
Sure. So I think considering the paucity of time, I'll just focus on a very high level key points. In all technology companies, as Weber mentioned, that in the current space, the tech deals are split into two. One are the traditional ITES, BPO sector services, and the other one is the newer age of technologies, which is the smart age, which is analytics, which is apps and mobile and SMAC. In all of this, one thing synonymous is IP. And in all of these transactions or in all of these companies, copyright is something which is, inherently created, which needs to be protected. So whenever you're looking at any of these companies from a acquisition perspective or from a technology transfer perspective, the key is, does the company actually own the IP? Have they validly protected it? Have they validly created it? And actually, do they actually own it? And most of this also gets covered under the Copyrights Act, depending on the business of these companies. So the interesting part about the Indian Copyright Act is, if anybody is acquiring IP, and a lot of these models are based on outsourcing development, R&Ds, and so forth and so on. If the contract does not specify the term and territory, as per the Indian copyright laws, it's deemed to be 5 years and limited. The territory is limited of India. Which means that tomorrow when an IP is with the company and the term and territory has not been specified and it's been acquired by somebody from somebody else, or it's been developed by somebody else for that company, you need to be mindful that the ownership in relation to that IP with that company would only be for the period of 5 years and would be limited for the territory of India. So in short, when you're doing deals, you need to ensure that when you're talking of IP and chain of IP, the IP sits till perpetuity and for all worldwide territories. Another unique thing under the Indian copyright law is that they actually go and say that when there are assignments which need to be made in relation to IP, it needs to be in writing and it needs to be signed. So that's another point which you should be mindful of. Coming back to the tech space, we see a lot of incubation projects and which are also government funded. It is extremely important that when you are acquiring companies which have been funded on these on these fronts, the documentation is looked at, because usually the rights or the government or the people who are funding these incubation projects would have the first rights of monetization. Last but not the least, open source becomes extremely critical in this industry. So please be mindful whenever you're acquiring any companies for the IP, whether the code or the platform on which it is built, to what extent is it proprietary coding, to what extent it's open source. So I thought that's this to sum up. Of course, there are a lot of other issues, but we can do a follow-up seminar on that. And on the employee front, there are various ways in which employees are taken or transferred. Since in this space employees are extremely critical, usually the buyer would want it from a resignation rehire perspective, whereby the employees resign on the payrolls of the seller and get rehired on the buyer's payrolls, because from that perspective there are no liabilities which are passed on to the buyer. It starts on a completely fresh slate. But from a seller's perspective, we've also seen that there's a lot of pushback. That there's an employee transfer, and that's an employee transfer under law. It's under the industrial laws of India. But the trick for the buyer in those cases that he has to ensure that the terms of employment are the same or more favorable, which creates an added onus on the buyer. And the other downside of this is that he has to recognize the terms of service for the purpose of gratuity. So all of these things, of course, get interplayed when the employees are being taken for the purposes of these tech transactions. Last but not the least, the most important and a softer issue is on the employee integration, because in this industry, what is most critical are the employees, because those are the people who are actually generating and they are actually developing the IP. So as a practice, we've seen that a lot of time is spent with the employees pre and post the transaction, just to ensure that there is cultural integration. And this becomes even more important when the offices are spread across various jurisdictions, which means that the employees are not housed at one location, they are spread across jurisdictions, in say 10 in India, 15 outside India, or in various states in India. So the integration becomes extremely important, because post the acquisition, if the business needs to be successful, the buyers and the sellers, the employees need to be, totally in sync. So I think that was a quick summary, Weber, and I would leave it up to you for the next question.
Thank you. We started with Karan, maybe we'll end with Karan too. Karan, when you look at document, there are well-recognized global deal concepts. We often encounter challenges with some of this in India, especially in relation to deferred consideration, earnout, holdbacks, indemnities, escrow mechanism. Would you throw some light on it?
Sure, thanks, Weber. Weber, like you rightly mentioned, some of these concepts have always been a challenge to enforce and implement, even document to an extent when you look at India-centric deals. Let's try and split them up a little, and if we talk about where the problem comes from, right? What's wrong with the deferred consideration? I think Josefa mentioned briefly, and you spoke about pricing guidelines and how they're applicable for inbound transactions. Now, that plays a big role on having a deferred consideration construct. Since you have to pay out in accordance with the pricing guidelines, and as you mentioned, if it's a transaction which is where the recipient of money is an Indian party, then you have a floor and otherwise you have a cap. Deferred consideration becomes an issue if it's beyond, say, a reasonable period of 5 to 6 months, because you fixed a valuation. The valuation may change, and then how much you pay will be, subject to and derived by what the valuation is at that time. Another situation where we've seen issues is when you're really dealing with this entire bucket of holdbacks and indemnities and what you do around them. And a solution that came out offshore and in different transactions was escrows, right? If you have an indemnity payout, you want to be sure that the payment comes through. Let's say these are specific indemnities and not just the typical indemnities that will have their own challenges of being litigated through the process of courts or other dispute resolution fora. The problem is this has to be paid. It's a specific indemnity. How do you do it? Unfortunately, the common concept of escrows that developed in more offshore deals has been less common in India, and the reason for that is multiple. There is actually one-fold, but has seen some evolution. Escrows were allowed, but of course you had the limitations on pricing, etc., that existed under the pricing guideline. Now, what the regulator then saw was that look, people are actually using an escrow, calling it an indemnity escrow or calling it an escrow for some other purpose, but really it was used to pay out more money or less money depending on which side of the pricing equation you were. To curb this, RBI in the beginning actually came out and said no escrows altogether, and then came out and said they gave us a leeway where they said you could have escrows for up to 6 months, and within those 6 months the consideration must flow one way or the other. They didn't specifically allow an escrow for indemnities or holdbacks or other things that we spoke of, like such as earnouts, etc., or cash ups. But there has been a lot of debate in the recent past. Couple of the last interactions with the regulators and ED show that RBI seems to be more receptive of indemnity escrows. Of course, there is an element of foul play that could be there, and they'd like to limit that. But that's something that we've seen in the development. An interesting thing that now we've seen gaining a lot of importance in India, which was common offshore, and to some extent even offsets these problems, is this entire concept of reps and warranties insurances. It's fairly common now that the buyer will actually buy a reps and warranty insurance, where one of the big insurers of the world are going to come ahead, do a quick diligence and do an understanding of the representations, warranties and indemnities being given by the seller, and step in and say that look, we insure these. If there are going to be defaults, we are going to pay under those. Their payout records and track records are pretty good. When I say that, I don't mean there are too many claims, and that of course is deal specific. But if there are claims, insurers have been known to pay out fairly quickly. This has become a concept that's being very well accepted in India, and to a great extent has helped us even come past this requirement of really having escrows or really having indemnity holdbacks. The requirements for indemnities are therefore a lot lesser because the risk that you're taking on is lesser to that extent. And what's good to know is that the kind of risks that are being insured under these reps and warranties insurances that are available today is fairly broad. What you will think will typically might get excluded or not, don't really get excluded, and they get insured to the extent that the diligence was done in a manner that was enough that the documents and the other information has been well recorded and well codified for you to pick up and work off.
Yeah. So sorry, one quick thing which is very specific to the tech space is we've seen a lot of hybrids as well, which is an offshore escrow which is backed with insurance, because again, coming to the tech space, the intellectual property and the infringement in relation to that intellectual property gets extremely important. So you've actually seen when there's a US piece, there is an offshore escrow which is always there to protect the deduct, which is backed by insurance.
Yeah. I mean, the offshore escrow also has a few more challenges, definitely
Exactly.
more kosher than having one in India. But
Exactly.
you're absolutely right, that's a combination that we'll be now seeing.
Thank you. I think I just want to add one point where we are seeing a lot more, where we are seeing people who are not typically given importance but gaining importance very soon is on competition law. Lot of transactions in tech space. Generally, you would not believe that, you would not expect that this will get captured under competition law for some reason or other. However, we are seeing that sometimes transactions, because of the size of the acquirer, sometimes because of the size of the target or combination or the structure, because it was done as an asset acquisition, you may need to go and get approval of Competition Commission, and this is something which you need to keep in mind. I just thought that's something which I should point it out. With this, I would like to open the floor for questions. I hope our team has given interesting thoughts, and if you have any questions, please feel free to ask them now.
Thank you very much, sir. Ladies and gentlemen, we will now begin the question and answer session. Anyone who wishes to ask a question may press star and 1 on their touchtone telephone. Participants are requested to use only handsets while asking a question. Anyone who has a question may press star and 1 at this time. Participants, if you'd like to ask a question, please press star and 1.
Maybe while we are waiting for some question to come, maybe I can ask a question to Rajesh. This is, a lot of transaction we see on, especially on software and BPO space, involve STPI or SEZ, and this raises some kind of concerns in the sector. Can you kind of give a quick overview on that?
Sure. I think especially for the tech sector, right? The concept of STP and SEZ. STP is a historical benefit which was there, which essentially it provided for certain income tax holiday for a 10-year period, and holiday as far as indirect taxes are concerned. The questions which always arise is more during the case of asset acquisitions. The question being that how do I sort of transition from let's say the target's business to the acquirers? There are certain procedures, specific procedures, which need to be followed in the which is called a bonding and a debonding procedure that needs to be adopted. The second issue that also comes up, and this is probably relevant more for SEZ, is that if I'm doing the asset acquisition, one of the things is that if as a acquirer I already have an SEZ, the question is that if I do an asset acquisition and I take over employees and people, is there any possible risk of me losing my SEZ benefit, or can I integrate them into my SEZ without me losing my tax benefits, which is available for SEZ? Usually the answer to that is no, that you will not lose out on those benefits. But having said that, the issue that always comes about is that today if there is a SEZ or unit that's being formed by the reconstruction or splitting up of another unit, then there can be a potential denial of benefits. Courts have generally looked at this, saying that these are benefits which that you determine in the year of formation and not otherwise. So which means that as an acquirer who has a SEZ unit, I have subsequently undertook an acquisition and I have moved the employees into the SEZ, I should not really lose out on the benefits. Again, these are very, as I said, very specific, either procedural or nuanced issues which arise primarily for asset acquisitions. And I think today most of the STP or SEZ units are really formed in the tech space.
Thank you, Rajesh. Any questions from the audience?
Participants on the audio bridge, if you have a question, please press star and 1. So no questions on the audio bridge.
Okay, great. I think our panelists were very, very clear in what they said. Okay then, I think, thank you. We are also on just about the closing time, and maybe we'll close the session. Thank you everybody for being there, and I hope it was useful.
Thank you very much, sir. Ladies and gentlemen, with this we conclude today's conference call. Thank you for joining us. You may now disconnect your lines.